Good morning. So let me please briefly introduce myself first. I'm Miriam Aid. I'm the ICCF representative for the MENA region, one of the ICCF representatives for the MENA region. And it is our pleasure and honor to be hosting this 9th Arbitrator Roundtable for the Middle East Pre-Moot this year. Nice will further speak about the Roundtable. However, I'd like first to express my honor and gratitude for this event, especially that the ICCF aims at promoting arbitration among young practitioners, and this is exactly the kind of events the ICCF would want to promote and support, because it both promotes students and helps students understand and engage in international arbitration processes, but also arbitrators from around the region. So we're glad to be here. I'd like to thank a few people for having this event. First, the Center for Legal Development program of the US government, especially Nice Abousi, for all of their support for this program throughout the years. I would also like to thank the Royal University for Women, Dr. Pasquale, for also supporting this event, hosting the venue, the catering, of course, all of the logistics. I'd also like to thank the CILE, the Center for International Legal Education of the Pitt University, for especially Professor Brandt for the program and for the constant support for this event. Finally, I'd like to thank the BCDR, MENA Chambers, Aisha, Dr. Ahmad, and United Milan Central and Walter Kluwer for their support for this event. I'd like also to call Ms. Ilham for Hassan to give a word on behalf of the ICC Bahrain, which has always been supportive for ICCF events, and particularly for this Middle East Pre-Moot throughout the years. So it's yours.
It's okay. The fonts are too small and I'm growing older, so my eyes are growing older too. Good morning, everyone. It gives me great pleasure to be present with you all today. Amongst us today are those who are masters in arbitration and those who strive to follow suit. And I'm excited, as I'm sure you are, to hear what each of the distinguished speakers has to share with us. I hope that it will be an interactive and fruitful session, and that each one of us will walk away having expanded our knowledge in the fast-growing field of arbitration. I am honored to have been invited by the organizers of this important event to be one of the speakers as an ICC court member. As such, I must give you, my audience, a brief on what the ICC court does, which is quite unique in comparison with other arbitration institutions. The main function of the ICC court are the scrutiny of awards before delivering them to parties to arbitration. The scrutinized award may be partial, inter, or final. Scrutiny of awards by the ICC court provides, in my view, a great deal of assurance and comfort to the parties to an arbitration, and that the tribunal's work has been scrutinized by the ICC Court Secretariat, which comprises a team of efficient, well-experienced members. and thereafter the court, which comprises the elite of arbitrators all over the world, from all over the world. The court also decides on challenges brought before it by a party or parties to arbitration, or to decide on the expenses and fees of arbitration when it is so required. The ICC court convenes to make decisions and respect of matters raised before it, normally once a month, at the ICC headquarters in Paris. Members of the ICC court represent their national committees for a term of 3 years, which was renewable in the past. However, by a decision of the current president of the court, each court member will serve a term of one term only. I hope, young arbitrators, that you all have the opportunity to serve as an ICC court member one day. Young arbitrators shine like a star, as only shining stars are seen, noticed, and admired. P.S. It's a man's world, as James Brown said. So girls, go out. Thank you.
One last welcome word from our partner from the BCDR, the CEO, Dr. Ahmed Hussein. Would you please come? Before we give the floor to Mace and launch the program.
Good morning, everybody. First of all, my name is Ahmed Hussein. I'm not a doctor. So that's one. I would like really to welcome you at the 9th annual Olympic Series Pre-Moot Arbitrators Roundtable. I would like to thank the ICC sponsoring this roundtable for the second year now. And it is really nice to see all these familiar faces that usually we see each year. And to the practitioners joining us for the first time, welcome to our ever-growing Pre-Moot family. Welcome, Chris. So, since 2011, we have witnessed growth on every level. We have seen students start off fresh as first-time competitors. A couple of years down the line, they then return to us as coaches. You can see the Afghan teams here. That's a good example for this statement. Fast forward a few years, and some are even back here with us today in this room as arbitrators. Anybody here? Yes, so we have it here, and Afghan staff team also. So this project of ever-flowing, promising potential could not have been tapped into and broken free without the contributions of arbitrators and legal practitioners who continue to show up year after year and share their knowledge and experience with the students, the future practitioners. In a world where business continues to expand, the rise of dispute become inevitable or inevitable, and in consensus, the legal profession is getting busier by the minute. The fact that all of you are taking the time out of your demanding, hectic schedules to be here with us in this mood gives me an undying hope. So thank you all. The law students at this mood are not only learning the arbitration process by practice, they are also soaking in the humility, selflessness, and sense of dutifulness toward building a better and more civil world for tomorrow. that they see from you today. So thank you all, and I'm truly humbled and honored to be here with you today.
Sabah al-Khair, good morning. It's lovely to see everyone here today. Again, my name is Mace Rabusi from CLDP. I'm an attorney advisor there. And I'm looking around the room, and it's a face I think I know about everybody in this room, and I think everybody knows everybody around as well. If you look to your left and right, we are not that many people this year. And this program, actually, to be quite honest, was put together this year, unlike previous years, almost in a 3-week period. And that was because of the US government shutdown that impacted the ability for to procure and to obligate funds in order to make the event happen. But even with that, the fact that we were still able to get everything together, our partners stepping up and contributing more, and our arbitrators, even though on a last minute's notice, were able to hop on a plane, drive, and fly over and join us this week, shows us that the people that are really here are the ones that are truly committed to making sure this program stays alive. So I want to thank you personally, and from all of us, from all the logos that you see up there, for coming, because we know how much of time and effort this takes. Speaking of logos, we're in a 9th year, and I was just speaking with one of our colleagues. I said, wait a minute, so the Pre-Moot is in its 26th year, the Hong Kong Moot is in its 15th or 16th year, and we are in our 9th year. I think very soon we may have the opportunity to transition from a pre-moot to an actual moot. It is a potential. And rightfully so, I'm going to call you Dr. Walid now. Just a funny story with that one later. As our good friend Ahmed has said, it's potential. But me being from the region, we hear that a lot. This area has lots of potential, but we always fall when it comes to the details. And so while our role for the rest of the day is to prepare arbitrators so that they can challenge the students and also themselves be challenged and use this as a professional development opportunity, also an opportunity to network, I will be pulling you aside and having a lot of conversations to discuss how we can all potentially be more involved in raising the bar for the 10th annual Pre-Moot. How this really all started, of course, I'll give you just a short summary. It was one man on a mission on a CLDP plane that went around the region over 10 years ago, and in 2011 actually, right? 2006, in trying to start developing the legal education in law schools. And CLDP then, the mold of technical assistance then, is then to work with judges and practitioners and so forth. And Professor Bren was like, wait a minute. Uncle Sam should be investing in the next generation rather than the current generation. And that was an extremely, extremely brilliant point to make at a very early stage of programming. Because the one thing I know as one from the area would say, we do have difficulty passing on the baton. Passing it on to the next generation has always been something that's quite difficult for this area. And I think the fact that he started to develop this Pre-Moot immediately with BCDR and then working with CLDP, slowly, this something has become into something much bigger. And the fact that we have here, and I think we all know, our colleagues from Saudi Arabia, the STCA, are here on board, and you have BCDR, you have ICC Bahrain. And you can tell this is not about which institution, which rules, who's going to take the market competition. This is the one day out of the year, we put that aside, we put our cases aside, and we look around and take a moment to take us back to the classroom. for ourselves and for the next generation. And that's what this roundtable is really all about. And I hope that you really use this opportunity to enjoy and engage and be as, have fun with it as much as you want. And that's what it is, really. You'll see that next year is the 10th year. And we hope that we'll have a lot more logos. And the logos of not arbitration centers, other wonderful institutions and agencies, but law firms, like Bina Chambers, who's taken the lead of coming here and offering an excellence award to students. It would be wonderful to have law firms provide internship opportunities and come and sponsor some of the program and be more involved. Because it's not just a wonderful opportunity, it's needed. If the US government didn't open up in time, we'll be very honest with you, because that's something I know how to be. We probably would have only had 14s, and it would have never been Pre-Moot. And it would have only been private schools, and not the institutional public schools, and schools that come from very developing and emerging markets. Iraq is on the cusp of signing the New York Convention. And actually, one of the main people that's helping pushing it from the bottom up is a Pre-Moot student that you heard his arbitration, his movement, Ali Debal, the red hat guy. You guys remember?
Oh.
He's the one who's working with the council ministers, who's now a major lawyer at a Tamimi firm. We have another one who's now a general counsel at another law firm. In Tunisia, we have judges. In Jordan, we have major partners at law firms. These students are no longer students, and they have earned their seat at the table. And it's our turn to make that happen for them. So with that, I'll stop talking, because I know we're all eager to start the program. But before we do, let's just give a few moments to thank RUW. Because RUW has stepped up to host the Pre-Moot again and again and again. And they do it completely selflessly, and the fact that whether, well, maybe it should be selfish, probably, trying to win. But the point being is the fact they've opened up their doors. They've committed their heart, their mind, and their money into the program. And a Pre-Moot is about a center, an academic partner, lawyers, and students all in one. And thank you so much, RUW, for not just doing the logistics, but really also putting the spirit of the VIS behind the program. So you're wondering how this roundtable really started. And it's all really, Mr. Rashad, it's your fault. You know that, right? It was your fault. We were in Qatar, and he walks in, he goes, look, I'm not ready. And then comes along Patrick Joyce into the room, and he goes, oh, well, I'm not going to make fun of your accent, because we'll do that later after the program. He comes up and he opens this big paper. I don't know if anyone was there to see it. It was a huge piece of paper that was a visual outline of the problem. And they just sat down on the table, and they were just discussing the problem and talking about, this was before arbitrator briefs came out early on to the problem. And I just looked at it and I said, aha, Professor Brand, that looks like a good program idea. So thank you two gentlemen for making a simple coffee morning talk into a wonderful addition to the program. And with that in mind, I would love to invite our colleagues that are going to be joining us for today that will be leading the discussion. Our man from Nebraska, but the godfather of the VIS Pre-Moot in the Middle East, Professor Ronald Brand. Come up. And the one and only Mr. Michael Patrick Joyce. Ms. Dani, I'm so glad that you're able to join us. Dani came all through Miriam. Miriam was very well to put all the pieces together and said, look, we need to start working more closely together, and she's a new addition to the team, and I think it's going to be a wonderful time to put a woman at the seat of the table, as Ms. Ilham stated correctly. And of course, the person who actually started this whole thing with asking the right questions, Mr. Rashad. So, I leave you in capable hands. It is now, I leave you to the mercy. So, good luck.
Good morning and welcome. It's really wonderful to be here. I want to thank all of the organizations that have made this possible. I won't go through the listing because you've heard them all, but it's really wonderful to have the kind of cooperation that makes this happen. But it could not happen with you who are here to be arbitrators. The students have been working hard Tuesday and Wednesday. They're working hard today, preparing their arguments, getting ready to make those arguments to you. But unless there are arbitrators to be there to hear the arguments, to push them, to ask questions, it doesn't really work. And so you are key to all of this, and I really do so much appreciate your taking time out of your busy schedules to be here to help us to contribute in this way to the next generation of lawyers, arbitrators in the Middle East. Because this is important. This, when these teams go to Vienna and when they go to Hong Kong, they represent not just their schools, not just their countries, they represent the region. And I can tell you that they are making a difference on other people's perceptions of this region and what is being done and can be done in this region. And it matters and it makes a difference. And so thank you for being a part of that educational process for the students. Now our goal is in a short period of time, we have a coffee break at 11:15. We have lunch at 1:30. But in the time that's in between that, before the coffee break and between coffee break and lunch, what our goal is to make everybody more comfortable with the problem. And because everything got delayed and you've received the problem later, you haven't had as much time to read it, look at it, and so we want you to understand it well enough to really ask good questions of the students. We had a presentation yesterday from one of the trainers on what kind of questions you can get from arbitrators. And they talked about bad questions and good questions and how to respond to bad questions and how to respond to good questions. But this group has been so wonderful in always having good questions. We're going to try to help create that structure. But what I like about this is it's always interactive, and we learn as much from you or more from you than you learn from us, because your perspectives help us understand things a whole lot better. So we're going to jump right into the problem. Michael is going to tell you the story of this year's Pre-Moot problem, because every problem, as you know, in arbitration or litigation has a story. And so we're going to start with the story, the facts, and then we're going to turn to the law.
Ron, thank you very much. May I begin by echoing your thanks to all of the organisers and supporters of this event. We're really extremely grateful to everyone who has supported the programme, particularly this year given the US government shutdown, and I fully associate myself with all of the expressions of gratitude that have been said so far this morning. Second thing that I'd like to say by way of introduction, just to pick up on one particular point that Mace made, and that was about the narrative of the MENA Pre-Moot, because we now are in our 9th year, and what has really struck me very forcefully as a practitioner is the short scope of a professional cycle. So the people that we first encountered as mootees came back as team coaches, went to other parts of the region or other parts of the world for the purpose of pursuing their legal studies to a very high postgraduate standard. We now see those same people back in the region, in transnational law firms, in top regional law firms, as general counsel, and that is the proof of the pudding being in the eating. That is what this, to my mind, is really all about. It's enabling students to have a first exposure at what the world of international commercial arbitration is all about. One hopes very much that they will enjoy it enormously and be enthused and follow that through as a career. That is indeed exactly what we're seeing. We're also seeing not just practitioners, but young academics being formed through the process of participation, young general counsel. And it's that holistic approach to skilling up, which I think is so very valuable. And that's what makes me come back year after year after year. And it's the enhancement of that narrative. And I think now the telling of that narrative across the whole region, which really is the most important thing, is something that the whole of the region has bought into, and the whole of the region should be proud of. And it's a message which needs to be distributed far and wide. Okay, so much by way of introductory points. Let's turn to the case study. By the way, can I just ask, is everyone can hear me and I'm not becoming too loud on occasion if I look towards the microphone and too quiet if I look away from the microphone? Everyone happy? Good. What was my first reaction when I read this year's case study? Well, what a stinker. It's a tough one. And there are so many aspects to this year's problem that even the problem setters clearly had to narrow down. And there are some wild geese which are left unchased in relation to the problem. Not all of the points which arise could possibly be followed through. So part of the challenge this year for arbitrators, it seems to me, is to tease out, separate the wheat from the chaff, separate the sheep from the goats, separate out the central arguments which need to be focused on from arguments which are there and which in real life would be explored, but which for the purposes of enabling students to show the skills that they've acquired in the 15 minutes of oral presentation, those arguments need to be left on one side and we need to focus on the core arguments. Now, Mace referred to the introduction some years ago of an arbitrator's brief, an arbitrator's analysis, as it I think is termed this year. That is a very useful document. You can get that on the PACE website, and I would strongly advise those of you who have not read that to have a good look at it. It's 20 pages, it's quite dense, and the purpose of me standing here this morning is really to take you through that orally to the extent that that's possible in the time, flag up some of the issues that are discussed there, point you in the right direction of the laws and the rules and the articles of the CISC which are central to an analysis of the problem. Ron will be picking that up in more detail in due course. And as we've already said, we want it to be interactive. So once the scene has been set, then do feel free to come back to us to ask questions. And we'll be throwing questions out, I hope, for your consideration, your response, your feedback. And that way we'll get a very good interactive discussion. So, what are the facts? Well, let's begin with the parties. The claimant is Far La Alivamento, and one is grateful that the organisers decided that Alivamento was not not only difficult to pronounce, but could be dispensed with. So the claimants are Far Lap, and Far Lap has a stud farm in Mediterraneo, where their star racehorse stallion is Nijinsky III. Far Lap has developed also, but not so much in the context of racehorse breeding, but for other livestock breeding and horse breeding. They've developed a mechanism and a process for freezing semen, which enables the quality to be maintained and the distribution of frozen semen to be effected internationally on a much easier and more reliable basis. It's also right to say that Far Lap, because of events in their recent past, are not in a strong financial position. And that may well become of relevance in relation to one of the central issues of this year's problem, which is the question of hardship. So much for the claimant. The respondent, Black Beauty Equestrian Limited, is based in Equatorial. Black Beauty is again a breeding centre for horses, but this time they have top mares within their fold, and the obvious thing is to put strong stallion line together with a strong mare's line and breed the next generation of racehorses. So in March 2017, Black Beauty approached Far Lap about breeding from Nijinsky III with some of their mares. And when you look at the problem, you'll see that there are 3 mares who are identified, and then there's a rather loose form of wording in relation to the possibility of the frozen semen being used not just for those mares, but for other mares. That raises a question which isn't really explored beyond the raising of the question in this year's problem, as to whether that requires the consent of the claimant to the use of the frozen semen with other mares, or whether essentially the wording which is put in the contract is more or less meaningless. And although I say it's not central to this year's problem, it does have a relevance because issues of good faith or bad faith are raised as between the parties. And just to anticipate events whilst dealing with this aspect, the respondent, Black Beauty, sold some of the doses, some of the straws of frozen semen. They sold on in Equatorial. The claimant sees that as demonstrative of bad faith. The respondent says, no, 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 we were able to do that. Again, it's part of the contextual background and surroundings. Now, going back to March 2017, you have to understand a certain amount about racehorse breeding. And that, of course, is one of the real-life aspects of being a legal practitioner. You suddenly find yourself having to be an expert in some area that you had no idea that you were going to have to be an expert in. And you're an expert strictly for the purposes of that case. So I think that as a legal practitioner, we have to have brains which are a bit like sponges. Not soft in the head, but sponges so that we soak up all of the necessary information for the case that we're involved in. And then at the end of the case, metaphorically wring out the sponge, wring the sponge dry, so that it's ready to soak up the facts and information for the next case. So you need, as part of this case, to understand a little bit about racehorse breeding. The conventional way of breeding racehorses is to make sure that the stallion and the mare are put together physically. But in the facts of this case, that was not possible, because in Equatoriana there was a serious outbreak of very virulent animal disease known as foot and mouth disease. And the effect of foot and mouth disease was that there were movement restrictions placed on animals. So Plan A didn't work. Putting Nijinsky and the three mares together was not a viable, it wasn't an option. So Plan B involves artificial insemination. And Black Beauty ordered 100 doses or straws of Nijinsky's frozen semen. Now, we know that the process that Far Lap had put in place was as reliable as any. So why, you might ask, do you need as many as 100 doses? There was a plausible explanation put forward by Black Beauty. It was in relation to their ability to use the straws after the temporary restrictions put in place by the foot and mouth disease, and to do with the cycles of the breeding cycles of the race horses, etc. That's what they said. But they also wanted, they had perhaps a hidden agenda. They wanted to have artificial insemination as a means, a more ready means of breeding. So they were pushing a political agenda. Maybe also they had in mind that if they got a whole stock of Nijinsky's semen, this is a very valuable stallion. Maybe they had in mind from the outset that they could sell them. Maybe there is more to this bad faith aspect than meets the eye initially. So we have the contract for the sale of a large quantity with a plausible explanation for the quantity involved. The process of negotiation started in March and was continuing apace, and the parties were coming together, narrowing issues, resolving aspects of the contract where they had differences of opinion to begin with. But then there was a catastrophic supervening occurrence, event, namely the car or taxi in which both of the contract negotiators for the two parties, the claimant and the respondent, as they turned out to be, the Far Lap and Black Beauty. The two contract negotiators were seriously injured in a car accident. So seriously that one of them was off work for a very considerable time, the other was in a coma. So the ability to access those who were in the know in relation to contract negotiations, and therefore the process towards contract formation, was impossible. So the ultimate contract was completed by people who were unfamiliar with the negotiations. In the course of the negotiations, areas of problem had been identified, choice of law, forum selection. We'll need to come back and look at the sequence of events in relation to that in some detail. Or I say, we'll need to come back. You'll actually need to come back and do that, because that will form the bedrock of some of the questions that you may want to be posing of the teams that you will be judging. So, choice of law, forum selection, also the delivery terms. The parties had been at issue as to what the delivery terms should be, and the respondent wanted delivery terms on DDP, delivery duty pay. Of course, that shifts the risk to the supplier, because they have to get it, they have to satisfy the DDP terms. If you're taking on more risk, then there is value ascribed to that risk, and you to reflect that risk in a change to the price goes up, and also you want to look at other mechanisms whereby you can offset the risk that you're taking on, which is conventionally through a hardship clause. So the parties, the original negotiators, obviously thought to one another, or thought about it and spoke. And at some stage it seems tolerably clear that they started off with the ICC hardship clause of 2003. But that was a model which they very substantially changed. And the change was in the process at the time of the car accident. Those who picked the contract negotiations after that were not as adept as the original negotiators, and we end up with a very unclear and vague situation. And this applies to a number of the issues which were outstanding. You've got the details in the papers, the brief memo which was jotted down from the final meeting before the car accident, 3 bullet points, clear in relation to one of them, what the two of them mean. So we were setting up this vagueness, this ambiguity, which sets up the competing aspects which each side will be addressing. In those rather unfortunate circumstances, the agreement was concluded on the 6th of May 2017, and it essentially involved supply by instalments, 3 instalments, of the full quantity of 100 straws, whereby it went 25, 25 and 50. But just before the 3rd instalment, a trade war broke out. I wonder where the creators of this problem got these ideas from. A trade war broke out between Mediterraneo and Equatorial, which resulted in a tit-for-tat imposition of tariffs, including tariffs of a swinging percentage, namely 30%, in relation to agricultural products. Now, I think for present purposes, we've got to work on the basis that frozen horse semen is an agricultural product. It may not be quite what the creators or those who fashioned the tariffs had in mind, but nonetheless, we are where we are in that regard. The profit margin, we know, as far as the claimant was concerned, was 5%. So you can see the disparity if 30% tariff is imposed on a contractual environment where the profit was 5%, then what was going to be a modest profit turns out to be a thumping loss if the claimants have to swallow the additional costs of the tariff under the DDP delivery terms and arrangements. Where do we stand? Well, this imposition of tariffs came, we're told, as a bolt from the blue. It was a very rare event. There was only one previous instance. And the imposition of the tariffs was at the turn of the year 2017-2018, just before the final installment, supply installment was due for delivery. So there were some negotiations, some discussions between the two parties. They were clearly inconclusive, and both sides went away, perhaps unduly optimistically, thinking that they had secured what they wanted. So the claimant thought that the respondent understood and was receptive to the problems that they were facing and would renegotiate the price, but there was no concluded negotiation. The respondent wanted to get the final installment of the straws, and they duly got the final installment of the straws before any agreement in the light of the imposition of tariffs had been struck between the parties. It was then that Black Beauty sold some, I think it's 15 of the straws, at a profit. And as I said earlier when I anticipated this aspect, the claimant regards this as a breach of contract because of the naming of the three mayors and the words associated with the three named mayors. And they also regarded this as bad faith. So the arbitration was commenced, and it's quite easy to state in general terms the issues between the parties. The claimant said, well, this matter is arbitrable, and we want more money. We want an adaptation of the contract, and you, the tribunal, it has the power, the legal power, to adapt the contract to meet the circumstances which have arisen. No, 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 says the respondent, not at all. They say, first of all, this isn't arbitrable, outside the scope of the arbitration agreement, outside under the hardship clause, which was negotiated, which, as I've already indicated, leaves a lot to be desired in its formulation. The hardship clause did not enable any sort of adaptation or therefore increase in the price, and it didn't enable the claimant to obtain more money. So we already have quite a nice factual matrix, quite a lot of legal principles buzzing around, beginning to think, gosh, thank goodness I'm not counsel in this one. And then, to use a cricketing term, a googly is thrown in. A googly is a sort of, it's a ball which is designed to beguile, and you think it's going to spin one way, and in fact it spins in the reverse way. So what is the reverse spin? Well, shortly before procedural order number 1, which was in October of last year, the claimant obtained information about the respondent's stance in another arbitration, where the boot was on the other foot, or perhaps I should say the shoe was on the other foot. The horse shoe was on the other foot. The claimant wanted to introduce this information about the contrary stance that the respondent had taken in this other arbitration into the present arbitration. It thought that you couldn't run with the fox and hunt with the hounds, to give you another animal analogy. But there's a problem, and that is that the information may well have been obtained illegally. Two possible sources for the information. Either the information had been disclosed by one or two disgruntled employees, or at least employees who had left Black Beauty's employment, in breach of a confidentiality agreement, or Black Beauty had sustained an illegal hack on their computer archives. I suppose hack is quite appropriate within the context of a horse dispute as well. Anyway, their computer archives had been illegally hacked. So we then have that as the wild card in the mix which is now presented for this moot questions. And the issues are set out in the in procedural order number 1, and they are as follows. Does the tribunal have jurisdiction and or powers under the arbitration agreement to adapt the contract which includes in particular the question of which law governs the arbitration agreement and its interpretation. Should the claimant be entitled to submit evidence from other arbitration proceedings if it is assumed that that information was obtained as a result of breach of confidentiality or the illegal hand? And the third question, which is substantive rather than procedural, is the claimant entitled to payment of the additional monies that they claim to be due under an adaptation reformulation, namely 1.25 million US dollars, which is essentially a straightforward compensation, 25%. So they would be cash neutral. They would neither make a profit nor a loss on that basis, or any other amount. And here one's looking at what the contract says, in particular clause 12 of the contract, and also if the contract doesn't help, whether any help can be derived from the system. So, a couple of procedural questions, quite chunky questions with a lot of meat on them. Does the tribunal have jurisdiction to adapt the arrangement between the parties under the hardship clause? Is there an ability to bring into the arbitral proceedings other evidence? And substantively, is the claimant or is the claimant not entitled to more payment? Now, just pausing there and stepping outside the facts and looking at the context of the competition. One question that I raised and chatted with Ron this morning was whether we have timing issues here, because historically it's been divided more or less half-half, the 15 minutes usually equally between procedure and substance, with perhaps 1 or maximum 2 minutes for rebuttal and surrogate. But here it seems to me that there is at least scope for consideration. It may not change your view at the end of the day, but there is scope for consideration as to whether you perhaps give a little bit more weight to 2 very substantial procedural questions, or whether that is lulling you and the team into a false sense of security. Because although it is much easier to state succinctly what is at the heart of the substantive question, if you really dig into the substantive question, then you have to look at provisions in relation not only to the CISC, you have to look into the unit law principles, and you can in fact dig very deeply into the substantive question, even though it's capable and susceptible of being stated very straightforward. So it does seem to me that there is a genuine question for the teams to decide. There isn't a right answer, there isn't a wrong answer, but I think that this is an additional interest to this year's problem. So, we have this prior and fundamental question, which is referred to in the procedural order number 1, namely which law governs the arbitration agreement. We have the substantive question, whether this is an extraordinary change of circumstance, and how should risk be allocated between the 2 parties. So far as the applicable law is concerned, and I've already referred to this en passant, but I think it needs to be reiterated. On this aspect, you do need to look at the drafting history. I'll come back to the drafting history in a little while. But of course, the arbitration is taking place in Danubia. The lex arbitri is Danubian law. And Danubian law follows more or less exactly an UNCITRAL model law arbitration. The law of the contract is Mediterranean. But if you look at the drafting history, there were issues raised and discussed between the parties as to choice of law, choice of forum, and a trade-off was at least under discussion. Some possibilities had been eliminated. There wasn't clear agreement as to how the parties intended to deal with this problem. Some teams may seek to spell out a conclusion that the parties got further than others. So we have a very interesting dynamic in relation to the law which is applicable to the arbitration agreement. In terms of the illegally obtained evidence, again, we have to look at how that is done. And in terms of the hardship clause, again, because of the negotiating process, we need to be asking questions about what does it mean? Does it have a meaning? Is it meaningless? Does it, if it has a meaning, cover the present circumstances? If the clause doesn't cover the present circumstances, can the CISC or UNIDROIT principles come to the rescue? Does the contract, as negotiated and as signed on the 6th of May 2017, does that represent the true intention of the parties? Was that intention clear at the time? Was it known between the parties? Or at least if it wasn't known between the parties, can you have recourse to the reasonable third-party observer? Would it be understood in a particular way, and only in that way, by a reasonable third party, whether you can then rely on the provisions of the CISC to assist, even if the hardship clause itself is ineffective and is pathological. The drafting history. Originally, Mediterraneo was suggested as the choice of forum and the choice of law. The respondent objected to Mediterraneo as the choice of forum and wanted Equatoriana. The claimant said they could accept arbitration, and then there are competing versions which you will see in of the draft clause, which you will see in respondents' exhibits R1 and R2. And the concluded version was an amalgam by people unfamiliar with the circumstances, doing their best, which I have to say didn't carry anyone very far at all. So we have a muddle, and we have the law of Danubia on the one hand, which has no express provision with regard to contract hardship or adaptation. But under the Danubian law, there can be an ability to adapt, subject to express agreement between the parties. Can express agreement be spelled out? And there is something called the four corners rule in relation to interpretation in Danubia, which ensures a relatively strict interpretation. On the other hand, Mediterraneo law has a power to adapt, even if there is no special hardship clause. One then is led into Article 6.2, particularly 6.23 of the UNIDROIT principles, Article 8 of the CISC, and in Mediterraneo, under Mediterraneo law, all the circumstances can be taken into account. So a much more permissive environment, legal environment, under Mediterraneo law than under Danubian law. The claimant is obviously going to argue that the more permissive environment of Mediterraneo law applies. The respondent will be saying no. So you have a lot of, to my mind, very intricate problems arising out of working through the drafting history and where we reach as a result of that exercise. In Turning to the admission of evidence, in the other case that the claimant wishes to bring in, the respondent had sold a mare, and that contract, that sale of the horse, was again subject to tariffs, but going in the opposite direction, so from Equatoriana to Mediterranean. And the respondent in that other arbitration had said, oh, well, this amounts to an unforeseen change of circumstance. The claimant is arguing in this case that there was an unforeseen change of circumstance. It would rather like to turn against the respondent's own argument in the other arbitration. And indeed, there is supposed to be a partial interim award, we know the date, the 29th of June 2018, available. But this is proving rather more difficult to obtain so far as the payment is concerned than it had thought. But in this partial interim award, the tribunal in that other arbitration had confirmed the power to adapt if the tariff created hardship. So you've got still arguments in relation to hardship. It's not a foregone conclusion, even in the other arbitration. So how should a tribunal deal with material, clearly relevant, but where the obtaining of that material is almost certainly by illegal means, either by a breach of confidence or through the illegal hacking? There's some help in the applicable rules of the Hong Kong International Arbitration System. Have a look at Article 22, particularly 22.1 of the Hong Kong rules. The modern law might provide some assistance too in Article 19.2, but there is no direct answer. There's nothing which is conclusive. So the participants will have to argue from general principles. What are the questions that they are going to be grappling with? On the one hand, the claimant will doubtless be saying, well, I have a right to present my case, and I have a right to present my case fully and in the way that I want to present it. This information about the other arbitration, clearly material, and it would be an infringement of my fundamental right. It would completely distort the balance of the whole arbitration process. You can see where the claimant's coming from, with an eye to arguments on enforcement if this question should go against the claimant. I have a right to present my case. You may ask to what extent is the partial interim award relevant? Because although in the general facts that I've already described, it looks to be a sort of mirror image. When you look at the more detailed facts, the clauses were different. The applicable law was made clear. There are material differences, which mean that it isn't a complete mirror image. So is it a mirror but with an element of distortion in the mirror? Does that element of distortion mean that although superficially the partial interim award has relevance, when you dig a little bit deeper, it doesn't have relevance and it can safely be left on one side? As arbitrators, you may want to be pressing these sorts of questions to see what response you can get from counsel appearing in front of you. On the other hand, the respondent says, I have a right to preserve the confidentiality of the arbitration process. Come on, what are the virtues of arbitration? It's supposed to be private, it's supposed to be quick, and it's supposed to be relatively cost-effective. Private, number one of the three attributes of arbitration that I've just articulated. This drives again to use a very accurate and appropriate metaphor, a coach and horses through the confidentiality of arbitration proceedings if you can bring in information from another arbitral process. Yes, we were involved. Yes, we had the same counsel. But you, the claimant, have nothing at all to do with that other arbitration. Do the rules again apply in this regard? You look at the Hong Kong arbitration rules, there are provisions in relation to confidentiality. Confidentiality not only imposed on the parties, but imposed on the tribunal. Now, obviously, usually that is there in order to prevent breaches in relation to that self-contained proceeding, either by the parties or by the arbitral tribunal. But here, some of the argument may centre on the ability to use that article for a somewhat unusual purpose. Is there an argument that the partial interim award is already in the public domain? Somehow the claimant is getting hold of it. So, has the confidentiality been breached at an earlier point in time? It may be difficult to get it. You may have to go and pay $1,000 to get it. Yes, the $1,000 might have to be in a brown envelope, and the meeting might have to be in a rather dark alley. But is it in the public domain? So, lots of questions in that regard. So far as the adaptation and the application of the hardship clause is concerned, here one starts, I think, with clause 8 of the contract, which is the delivery duty pay provision. Then you look at the contract negotiations, that this was originally not included. It was something that the respondent wanted. The respondent wanted for particular reasons which don't cover the circumstances that have arisen, but that was included. The DDP arrangement for delivery and the price were negotiated and the price changed. And it was accompanied by the insertion of the modified hardship clause, which is clause 12 of the contract. What does that mean? We're back to some of the issues that we've already been talking about. But one question which you may want to pose in considering the problem is, was there hardship? Tariffs are tariffs. Is it such an exceptional and extraordinary circumstance that it amounts to hardship? Was it covered, if it does amount to hardship, was it covered by the modified hardship clause, if it has a meaning? And if not, then, as I've already mentioned, you look at Article 8 of the CISG, you look at actual intention known between the parties, A1, or intention discernible on a clear basis by a reasonable third party, Article 8.2. You can look at the, again, the factual matrix, the build-up to the contract conclusion. And there's clear indications that the claimant was risk-averse. So the claimant would be wanting to have some sort of protection. It's not as if we are without any information in that regard. Does that desire on the part of the claimant carry the claimant home in relation to the interpretation of the wording that we've got? On the other hand, the respondent was clearly concerned about the breadth of the original hardship clause and wanted it narrowed. So you've got an indication as to where both of the parties were, unsurprising positions so far as both of the parties. But what happened in that space between them? Was there a space? Was it bridgeable? Was it bridged? Where are we? Then we've got some particular phraseology points, meanings of construction in relation to comparability. The hardship provision talks about matters comparable to health and safety requirements. Now, comparability is, it's one of those words where you think you know what it means, but then when you scratch the surface, there's a bit of imprecision, a bit of vagueness. If you're talking about matters similar to health and safety requirements, are you talking about matters which could pose a threat to bodily existence in terms of risk of injury or risk of disease or illness? Is that what comparable to means? Or does comparable mean, well, health and safety requirements, infringement of that is pretty serious. So anything which has pretty serious consequences is comparable to an infringement of the health and safety requirements. What's actually meant by comparability? And also, you can have the same issues, or similar debate, in relation to foreseeability of tariffs. Finally, for my presentation, the adaptation under, which is the substantive argument. And here one is focusing, and Ron, I'm sure will be picking up on this, in Article 79 of the CIS. We start from a basic question: is there a hardship concept within the CIS? Probably yes, because you can construe the word impediment broadly, and probably the second strand to the argument would be that the gap is plugged in any event by Article 6.2 of the Unidroit principles. But I'll let Ron develop all of that. Then one's into other provisions in the CIS, Article 7.2, Article 9, and then you relate all of that legal analysis back to the factual circumstances before us in this problem. So you go back to Clause 12 of the contract. Then there's another issue as to whether Clause 12 can be said to be a derogation and therefore whether that ousts the application of any provision of the CIS in relation to hardship doctrine because of the application of Article 6 of the CIS. So you've got a lot of, this is why I said, although it's quite easy to state the substantive issue as an issue, when you start drilling down into how you analyze that issue, you get into close quarter combat with quite a few provisions of the CIS, and you have to be looking at the scope and the application of Article 6.2 of the Unidroit principle. So, I hope that is a useful introduction. I hope it summarizes and does some justice to the arbitrator's analysis, which you all have access to. And I hope that it's also provided a bit of food for thought on what I think is a really interesting and very challenging problem this year. Thank you very much.
For you.
Yeah.
As an arbitrator, how often have you actually adapted contracts?
Never.
Have you been asked to do it quite frequently?
No. No. But
Has anybody here in an arbitration ever seen an adaptation of a contract where the arbitrators are asked to do this?
We've been
Okay.
asked to fill in terms that never change the material terms.
Yeah.
A little hidden bit of information on this problem. One of the most interesting ways to research the problem here is to think about, well, who drafted and have they written anything? And one of the directors of the Pre-Moot is Stefan Kroll, who's a professor at Hamburg. And it just so happened that Stefan Kroll, in his, I think it was 1994, PhD dissertation, wrote his dissertation on adaptation of contracts. And it seemed to take the position, as I understand it, that you should allow adaptation of contracts. But this is an important question, because you see what happens here in the facts. And you have an event that increased tariffs that we all say is foreseeable, but was it foreseen by the parties? Okay, and the clause uses the word unforeseen, not unforeseeable. Okay, so this is the classic kind of distinction between, and the adaptation question brings it out, pacta sunt servanda, do you hold someone to the contract, or when there's something that has happened that the parties didn't really think was going to happen, do you simply go to equity and fairness as a result? And can you do that? And all of that brings out in this problem the question of, well, you can if the law says you can, right? So what is the law? And there are very difficult issues of applicable law here. But it starts with the contract, and if in the problem, I think two places in the problem are really important. The first one is the procedural order on pages 51 and 52, because the tribunal has said, here are the issues that we're going to hear argument on. The first one is, does the tribunal have the jurisdiction and power to deal with the question of adaptation at all? Okay, so the respondent said, here's the easy way to get rid of this. We'll just say you can't even, we don't have to argue adaptation, whether you could do it happens or not, because you don't have the jurisdiction. And that goes back to the fundamental arbitration concept of consent. And what did they consent to? What's the scope of the arbitration clause? Okay. Second issue is the evidence issue that Mike has set up very nicely. Okay. And then they say the third issue, but it has two subparts. Okay. Is claimant entitled to the payment of the price resulting from an adaptation, either under the contract or under the CISG? Okay. Now, and the second place in the record that those issues make important is page 14, because 14 has the contract provision. Obviously, when you ask what is the law is what the parties have chosen in the contract, what they say the rule is, right? But as to the first one, the jurisdiction question, if you look at paragraph 15, or clause 15, any dispute arising out of the contract, that seems broad, right? Except that in the Hong Kong International Arbitration Center's suggested standard arbitration clause, there's language that makes it even broader, and that language is left out. So should we assume that because the language is left out, they mean that they intended to narrow that? And does that kind of a clause, I think, if you're an arbitrator, you want to say my jurisdiction, the scope of my jurisdiction extends to everything, right? But it really extends to what the parties have consented to. So what have they consented to in clause 15? And then if you go up to clause 12, you get to the specific question about hardship. Seller shall not be responsible for lost seaman shipments or delays in delivery not within the control of sellers, such as or acts of God, neither for hardship caused by additional health and safety requirements or comparable unforeseen event. And you see the difference in the text here. You see italics, which was added in the course of negotiation to language that had already been suggested. So we have the words in the contract, and we have a lot of information about what the parties discussed, both before the automobile accident and afterwards, in negotiating that contract. And so one of the questions is, what was the intent of the parties when they put these words in? Do we hold them simply to the four corners of the contract? And as Michael has indicated, the domestic contract law, which is an adoption of the Uruguay contract principles, in all three countries, Mediterranean, Equatoriana, the countries of the parties, and Danubia, where the arbitration occurs, has the Uruguay principles. But in Danubia, they've changed them by putting in a four corners rule, the United States calling a parole evidence rule, a rule that says once the parties have written the contract, you look only at the written contract, you don't look outside of the contract to determine the intent of the parties. You can't look to prior negotiations and say, well, you said this in negotiations, if it's not in the contract. Okay? That's why American contracts get much longer than contracts in other parts of the world. All right? And UK, has a parole evidence rule. So it's the same thing. So, where does that put us? Now, let me step back on logistics, because we've had an adjustment in our logistics for the day. We still have coffee at 10:15, so we'll get you there for that. But instead of doing lunch at 2:30 after that last discussion, we're going to do our lunch at 1:30. And to 2:30, and then go to the afternoon symposium. In order to make it work between us and the students, we're going to go to lunch at 12:30 to 1:30, then come back here, and from 1:30 to 2:30 wrap up the discussion. And I think that's good, because you'll have a chance to discuss issues over lunch and come back and have another shot at them together here. So I really kind of like that change. But then we'll go until 2:30, and then at 2:30 we'll immediately move to the symposium. Okay? So we've got about 15 minutes here before coffee, and I'm going to suggest that we take some, are there questions, issues, thoughts about the issues, the arguments here that you have, so that we can think about those and incorporate them in the further discussion.
Just a quick one. I was reading class 12. Is there a punctuation problem?
Is there a punctuation problem in clause 12?
I don't know. Because
Well, yeah, clause 12 is interesting because you have the disjunctive or acts of God.
yeah,
And the question is, what does that refer back? What does that disjunct from?
right. And where does hardship fall as well? Because if the clause was meaning to mitigate the risk of just the loss of Siemens or delays,
Yep.
not hardship, then adaptation is not related to this clause whatsoever. It's called the condition.
Yeah, so you've done.
But if hardship is a second risk that they're trying to mitigate, but the punctuation seems a little bit odd over here with where does hardship fit in that song?
Not well drafted, is it?
I don't know.
So the question is, what was the intent of the parties in that clause, and how do we determine it? Because you could say, seller shall be not responsible for lost Siemens shipment or delays in delivery, and due to this list of things, including acts of God. Or you could say, seller should not be responsible for lost Siemens shipments or delays in delivery or acts of God. And the results of those different constructions are totally different, because one is very limited,
Yeah.
and the other is broader. And so that's an issue. Good.
So I'm struggling with the basis of denial of jurisdiction for the tribunal based on the remedy requested. To me, it seems to flip everything sort of end over front, right? So if the parties asked in the remedy section for an adaptation or any other remedy that the tribunal finds just, right? Wouldn't that open it up to jurisdiction then? Or is it sort of a, well, if we can't adapt the contract, then we really shouldn't bother, so we can't do it anyway, so we don't have jurisdiction. So to me, it seems to really flip over itself as to how you determine the basis of jurisdiction based on the other.
Well, yeah, and this, yeah, that has issues for analysis, but it also has issues for how the moot process works here. Because I think in a normal arbitration, you would hear the jurisdictional arguments, and if you decided you didn't have jurisdiction, you should say, we're done, right? And you wouldn't go on to the substance. But here, you will have to, as arbitrators, hear the jurisdictional argument and then say, we will withhold our decision on jurisdiction and move on to the substance argument now. But this actually does mean that Article 15 and Article 12 both relate to that first jurisdiction and power question. It's actually possible we could have jurisdiction to hear that the scope could be large enough, but that Article 12 doesn't allow them to have the power to consider it. And so that's a possibility here. And this leads us to kind of how the students are structuring their arguments. And Michael has suggested that there's a kind of fundamental immediate decision up front as to how much time you allocate. And I'll tell you how this, it is, those of you who have worked with us on this before know that it's kind of this moot process, that the two student teams are, when they enter the room, they decide between themselves how they plan to allocate the time and do that, and that the arbitrators have the authority to say, no, we want it done differently, but normally won't do that. And so, and what is occurring is the students are moving all toward the respondent going first on the procedural issues, because which is interesting because the respondent has the burden on the jurisdiction, the claim of lack of jurisdiction power. But on the evidentiary question, you can argue that the claimant really has the burden on that. Then you might split the first one up, 7 minutes on one and 7 minutes on the other, but that gets a little awkward. So the respondent is going first on both of those, followed by the claimant. Okay, but then on the substance, the claimant is going first, followed by the respondent, and most all of them, as far as I can tell, are splitting it. They're choosing to have each advocate do 14 minutes of main argument with 1 minute for rebuttal or surrebuttal. So that's just so you're aware of that.
I have just a related question, but an extreme question. If Clause 12 had actually expressly mentioned that claimant had the right to adapt, would respondent have still been able, to still challenge the jurisdiction of the tribunal based on the fact that, yes, it can adapt, but it's for the courts to adapt, not for arbitrators, because it's not in the arbitration clause?
So yeah, if Clause 12 expressly said that it was a hardship adaptation clause that said that there can be adaptation, would Clause 15
still excluded
still
give the power to courts, for example?
I think the answer to that is you've got to go back in the hypothetical to look at what the contract says and if there is an authorization to adapt and the dispute resolution mechanism is in arbitration. Seems to me that it is necessarily implicit, if not express, that the arbitration tribunal has the power to adapt.
But this makes it for an interesting application of the separability doctrine, which normally says you separate your analysis of validity of the arbitration agreement and the rest of the contract, but you can't understand the scope of the arbitration clause without, in clause 15, without looking to what they're authorizing them to do in clause 12.
Especially if the reference point is the consent of the parties. I mean, otherwise we end up in schizophrenic situation.
Yeah.
So,
I agree.
So, and I think we are also interested in having a more consistent construction of the contract. So if it is very expressly authorized by the parties for an adaptation of the contract, even though it's another clause than the arbitration clause, I think it puts us in a situation where we need to interpret the consent.
And it also brings up the difference of phraseology between what was actually agreed upon and what is suggested in the Hong Kong International Arbitration Centre. Because it may be that by narrowing the scope of the arbitration agreement, this adaptation might not be a dispute. It might not be a dispute arising out of the contract, that is, the respondent's argument. But it might be a dispute, etc., arising out of or relating to the contract. So you may, by narrowing, have excluded and therefore leave in a sort of no man's land the point that you're raising.
Because it's an argument that arbitration is exceptional, and then courts always have general jurisdiction. So if something is not mentioned expressly in the arbitration clause, let's say that's an argument, we go back to courts. And even if adaptation is in clause 12, if it's not mentioned that the arbitrator can adapt, we still go to courts to enforce our clause 12.
We can have an interesting debate about whether in all jurisdictions courts have a general jurisdiction. But Ziad and Sam have points, so let's bring them in as well.
I was wondering if there was an option to go back to the discussion on whether they have the right to adapt the contract and whether they have the right to act as a non-proposal third.
Yeah. It really illustrates how intricate the procedure and sometimes issues are. It's back and forth between procedure and
follow-up question on the ad. I mean, it also depends on what the scope of the adaptation is. If the scope of adaptation is very limited and very narrow, it moves more towards a remedy than actually adaptation. So we're changing, and if the scope of adaptation is broad, expressed by the party, then what's the other thing? I mean, opposed term, maybe it's two different things.
And how do we determine what the scope of arbitration is? We look at the clause.
Yes.
But is the clause clear on what the scope of arbitration is?
But from a practical point of view, if I was an arbitrator, I mean, the seat of arbitration is where the award is either going to be ratified or enforced. I mean, at least ratified. So I would go to the law of the seat of arbitration, which in this case is.
And which law of the seat of arbitration you go to?
It's the one. It's in this case.
But the arbitration law or the contract law?
No. I mean the arbitration agreement. It expressly says Danubia, right?
Danubia. The seat is Danubia.
Yeah. So I would go to that law.
So what law of Danubia are you going to go to? We were told a number. You go the arbitration law of Danubia is the UNCITRAL model law. Okay, but the UNCITRAL model law doesn't tell us much about what the parties mean in the contract.
I would then consider what a judge in the court will look at, how a judge in the court will look at it. Because in practical, that court is going to be deciding if it's ratified or not.
Okay, but what you have done is I think led us to what is one of the most important questions here. That this is a problem that depends on the corners you turn in determining the applicable law. Okay, because the question here on clause 15 is what does it mean? Well, that's a question of contract interpretation, right? And if we go to the UNCITRAL model law in Danubia, which we're led to because that is chosen as a seat, the model arbitration law doesn't tell us anything about contract interpretation. So we have to go to contract law. So the question is, what contract law do we go to? And we're told there are two different, that Danubia has a little bit different contract law Now, Mediterranean, Equatoriana, and Danubia all have the UN Sales Committee, the CISG, right? And if we go to the CISG, we have two important provisions on interpretation. First, Article 7 on interpretation of the provisions of the CISG. But what we're really dealing with here is the interpretation of the contract. And Article 8 tells us that for purpose of the convention, statements made are to be interpreted in accordance with their intent. It's a subjective intent test, but it's limited by where the other party knew or could not have been unaware of what that intent was. That doesn't help us much here. There is stuff in the record about subjective intent, but it's always hard to prove that the other party knew or could not have been unaware of your subjective intent. So then we go to the objective intent test in paragraph 2. If the preceding paragraph is not applicable, statements made by another conduct party are to be interpreted in accordance with the understanding that a reasonable person would have had, an objective intent. But then all of this has the gloss of paragraph 3, determining the intent of the party or the understanding a reasonable person would have. Due consideration be given to all relevant circumstances of the case, including negotiations, any practices, anything in the record. Okay, so the parties can argue anything in the record that leads you to broad scope or narrow scope. Okay, but that is if this is the applicable law. Okay, now what if Danubia domestic contract law is applicable, and we are told in the record that that has a four corners rule? That's very different than paragraph 3 of Article 8, which allows us to take into account anything during the course of the negotiations and performance.
In this case scenario, is Danubia has more than the model law?
Danubia,
I mean, in our case, and in this example.
Danubia has the UNCITRAL model arbitration law.
Okay.
It has the UN Sales Convention, and it has the UNIDROIT principles, but modified to have a four corners rule, because the UNIDROIT principles without that modification basically is the same as paragraph 3 of Article 8 of the CISG.
It also has the exceptional conferral of powers under Article 28 of the model. So it's another exception.
Article, was it?
Is the exceptional conferral of powers regarding adaptation under Article 28 of the model law. So the practice in Danubia, the arbitration practice in Danubia, what is to give for exceptional powers to make express reference in the arbitration clause in order for the arbitrator. So it's an arbitration practice within Danubia, irrespective of the contract scope.
Yeah.
So this is any arbitrator, if you
It's on Article 28.
yes, if you go back to question
36.
yes, question 26.
36.
No, 36. Not only does it say that Article 28, but in general, the practice of the courts is to require express conferral of powers to exceptional powers such as adaptation. Yes.
If it's expressed, and one of the issues is
Exactly.
whether you can
The
spell out
arbitration
express
practice, not only the
agreement.
contracts practice.
Well, and it's interesting here because you look at Article 28.3, the arbitration shall have power to decide that calculation. That's in every set of arbitration rules you'll find. Has anybody here ever been involved in an arbitration or ever seen a contract where the parties expressly
Yes.
said you may decide exactly how it's going? You have?
Yes. It's a practice, a wide practice in domestic arbitration in Lebanon.
Domestic arbitration
Yes.
in Lebanon. Outside of Lebanon, has anybody? I've never heard anybody say that before. But that's very. Has anybody seen that outside of
Have you
Lebanon?
have you ever heard someone say the arbitrator can rule exactly its role in accordance with Lebanese law? Now that's even more complicated. I have two clauses.
Okay. But there's one argument here is that adaptation is exactly outgoing. And if they didn't do it, and then under the UNCITRAL model law, it has to be expressed or it don't happen. I mean, that's one argument that could be made here, that somebody can say, well, look, adaptation is, as people suggested earlier, so unusual, and it sounds like exactly what both. It sounds like just saying, do what is fair, right? And Article 28.3 says if you're going to do that, it has to be expressed, and it's not expressed here.
Rob, before we have a break for coffee, can I just come back on Sam's point about whether there is a punctuation error in clause 12? It sounds such a small point, but I think it is actually such a big point, because I was just rereading clause 12, looking at the punctuation and looking at the structure. So if you combine punctuation and structure, you can make clause 12 mean about four completely different meanings. Now, I strongly suspect from what I've been hearing on the feedback from the training sessions that this year, more than any other year, we've got teams who are really getting to the level where they need to be pushed on this sort of fine point. So it's a real paradigm example for all of us here, not to decide what those four meanings are in plenary session or in committee, but to actually go back and read and think about it. And then we've got a range of arguments to put to the opposing arbitrators, and I suspect they're going to be at this level this year.
And now, you can say that, look, if the parties didn't make it clear in their contract that they chose the applicable law, where does that take us? Okay, because if you've got the default rules in the law, and you can add to them or change them in the contract. But if you haven't added to them or changed, then you, in order to understand where the parties are, you go back to the applicable law, right? And there is no hardship provision, there is no adaptation provision in the CISG, okay? And they chose as applicable law the law of Mediterranean, including the CISG. There is, however, and I'll just go to this and then we'll take a break, but in the UNIDROIT, see, well, let me stay with the CISG for just a moment, right where we were, because this is important in order to get there. If we did, because the sales convention doesn't have anything on that, we are left with Article 7, which tells us how to interpret the sales commitment. It says, in the interpretation of the convention, first, regarding to its international character, that means they can cite to you cases from anywhere in the world that have dealt with this issue if they have them. But then paragraph 2 is important because it gives us the cascade here. Questions concerning matters governed by this convention were not expressly settled in it are to be settled in conformity now, which tells us first, if they are expressly settled, we're done. We stay with the sales convention. But if it's not, then we look to the general principles on which the sales convention is based. That's, in civil law systems, kind of standard way to look at a code, right? But then there's an acknowledgement that even looking at express terms and general principles, there can still be gaps in the CISG. And at that point, you go in conformity with the law applicable by virtue of the rules of private international law. Now, then the question is, well, and all of the states here, all three have adopted the recent Hague principles on applicable law, on choice of law, but which start with party autonomy and then have a closest connection rule, but all of them have the UNIDROIT principles, right? So no matter if we're led to Mediterranean or Danubia or Equatoriana, which are about the only places you would be led to by the rules of private international law, you get to the UNIDROIT principles. And just to set this up for further discussion, in the UNIDROIT principles, if we go down to Article 6.2, we see the following. Oops. Sorry here. There's a lot of 6.1 to get through. There. 6.2.1 says when the performance of a contract becomes more onerous for one of the parties, that's what we have, right? That party is nevertheless bound to perform its obligations subject to the following provisions. So we start with kind of pacta sunt servanda modified, and the modifications are 6.2.2 and 6.2.3. So let's look at it. There is hardship where the occurrence of events fundamentally altered the equilibrium of the contract, either because the cost of a party's performance has increased, or because so increased in cost in the Unidroit principles is hardship. Okay? But that just tells you what hardship is. But then if you look at 6.2.3, you get the following. In case of hardship, the disadvantaged party is entitled to request negotiations. Now that we're not in that. The request shall be made without undue delay. But then the request for negotiations does not in itself entitle the disadvantaged party to withhold performance. But then, upon failure to reach agreement in negotiations, either party may resort to the court. And if the court finds hardship, which means increase in cost, it may, and look at B, adapt the contract. So, but here's the problem. You get to the Unidroit principle only if the CISG doesn't end the matter and general principles don't end the matter. Okay? But what we find is that the Unidroit principles do specifically authorize adaptation in the event of hardship, and hardship includes increased costs, but with clause 12, can you get to the Unidroit principles or have the parties, in effect, derogated from that, so you provided their own rules so you don't go to the default law that would exist if the contract had changed that. Those are all issues that the students can and should address with you. Courts and tribunals have an obligation of good faith in applying the convention. But note that in Article 8, when it comes to interpretation of the intent of the parties, there's no express obligation of good faith. Okay? And so some commentators have suggested there is an obligation of good faith on the parties to a contract, but they found it only in general principles. There is no express obligation of good faith on the parties. There is an express obligation of good faith on courts and tribunals and those who are interpreting the convention, but not an obligation of good faith in contract negotiation and performance. No express obligation. And the question is there an implied such obligation? Because in many legal systems that exist, but it's certainly not expressed in the convention.
Just a question. Assuming there is, how is that relevant or solved?
Assuming there is an obligation of good faith, how is it relevant to resolve the issue of adaptation? Good question.
Yeah, but we have to see in the general principle of unity law whether there is this obligation of good faith.
Yeah. Okay. Actually, in this, yeah. But yeah, and does good faith get you to support in one way or not the claimant's argument that they should get $1.25 million, basically, is the question you're asking. Now, but having said that, whether or not good faith is a general principle, the Unidroit principles clearly do place an obligation of good faith on the parties in the contract negotiation and performance process. So if we get down to the third step, in Article 7.2, there clearly is an obligation of good faith. In this case, now it wouldn't happen if the domestic contract law was not the unity law principles and if it did not have an obligation of good faith at that point.
I'm prepared to challenge your view about Article 7 and the observance of good faith. So I accept that the originator, the introductory words of Article 7 are in the interpretation of this convention. So yes, we're talking about the convention. But then you are, or the reader, is required to have regard to the observance, amongst other things, the observance of good faith in international trade. Now, that's something which you're having regard to. That's external to the convention. And it seems to me that although the introductory words are limiting, they are only limiting because of the focus of Article 7. But inherent within Article 7 is recognition that good faith in international trade is a general principle, because you cannot be required to have regard to that which is not objectively a general principle. And if this were out of a geometry textbook in school, I would add QED.
I would say you may be right.
You've got 10 minutes.
You may be right, but not an obligation of good faith that's expressed in the convention, but is a matter of general principle. Which means you're using 7.2 to refer to 7.1 to elevate general principle, to good faith, to the level of general principle.
So, as I say, QED.
Okay, we have some procedural matter that has to be taken care of before lunch, and we want to make sure you get to lunch. Now we're going to break for lunch at 12:30, and we're going to start again here at 1:30 because we need to deal with what we're going to do here from 1:30 to 2:30, and then from 2:30 we're going to just switch right over into the symposium. Okay?
I won't take too much of your time. So, a few important notes. There's very few of us this year, but there's 17 teams. 17, which requires, let's see, 5 rounds, general rounds. Requires a quarterfinal round, a semifinal round, and a final round. And so what we're going to be asking is a very, very heavy toll that we're very much willing to pay the price for later on. But wish that you are going to be very patient with us as we develop the arbitrator schedule. It will be posted and provided on the WhatsApp group in addition to pages of it by the end of this session. You'll see that there's not long breaks. It's about 15 minutes between each round, so very quick turnaround. And tomorrow's going to be a very, very long night in comparison to what we usually have. Quick, we usually have to finish up by 5. Tomorrow we won't finish up till probably 7:45, in which all of us then go back to the Sofitel, and if you are local, we urge you to come to the Sofitel. The hotel has arranged for, I think, like a dinner at 10 BD for all of us to be there, and that's when we announce who goes to the quarterfinals at 8 p.m. at the Sofitel. And they'll all be together outside. It'll be nice and festive, so it should work out. But so it's extremely important. So when you go back to the hotel, we're going to give them all your names. Unless you are not coming, let me know. So we give them a head count so everyone can pay individually. So that's on logistics. Also, ECDR, as you know, hosts the annual gala, and we need to know numbers. So if you're not coming, please also let us know, so that way we can give the head counts to BCR and ensure that our dignitaries are seated where they need to be seated. Scoring. This is not Vienna, but we are trying to get teams to the top 16, and we're trying to get them further. In order to do that, we have to push them and push them hard. So I think you've seen the scoring sheet before, and you'll get all this material, and you'll have sheets and everything ready to go. And you know, you remember this, you fill this out and you write the team member, and the grade is from 50 to 100. And yes, in Vienna they give you a little bit of criteria of, you know, what are some of the ways that you can do. But this is the Middle East, and if we're going to get the Middle East to be on equal footing with the rest of the world, here's some good pointers as far as where everyone should be, because every year we see extreme variations in the scoring. So in order to get everybody on the right page, and this will be provided for you, I'm not technologically advanced to do it this way. Yeah. That's funny. Here. Apologies, I know I have short time. Here. Excellent. Really, no one should be getting excellent. No one is near excellent. We hope that they're going to be excellent in Vienna. This is a pre-moot. So there's really, unless it's a team that is so unparalleled in understanding the facts, the case, and brings in cases that are outside of what has been generally said, and they're just, you think that they are round 16 qualified. But generally, probably 9 times out of 10, no excellence. So we're really between the very good, and the needs improvement. I'm going to start from the bottom and really work the way up. Now, what we mean by 50 to 59 is poor management of time. They go over their time, they constantly ask for additional time, they're shuffling papers with each other to manage their time, the alarm goes off on their iPhone, that type of thing. Poor structure of the argument. You can't really understand where they're going. There's not a clear roadmap. They don't really know the order of the argument, the way it should be presented, well, not should be, as suggested to be presented. Poor understanding of the facts and records of the case. Now, this is hard to decipher. Remember, with these students, English is probably their second, and in some cases, their third or even fourth language. So sometimes it's very difficult to get them to understand what you're asking and to get the response in the language and the words that you'd like to see fit. So make sure you understand the difference between that when you're deciphering whether they really know the facts and if they really know the record and the case. So it's important that when you ask a question, make sure that you ask questions that are quite simple, using simple language, simple words, so that they can understand you and give them that opportunity. Remember, you're trying to help them advance. So that's the important point to keep in mind. Non-responsive to questions. We get this all the time. Sorry, what's the question? Sorry. I can do that because I'm from here, so you can do that. So just maybe they don't understand your question, or they're truly trying to avoid it. And they do this all the time. They're really good at avoiding. Unprofessional demeanor and poor body language. Some of it's cultural. Some of it comes very defensive, and in their responses, like, how can you tell me, I just told you the argument. Well, I don't understand. I don't understand what you're trying to say. I just said, price adaptation is covered. That's it, done. So that's exactly where needs improvement is. So we're really between good and very good, and I'll quickly go over good. Understands the order of arguments. It's the same record that you've been hearing here. The same kind of record player that's been going around. Illustrates some strong arguments. Arguments that really make you, write them down. Arguments that are noteworthy. Not 5, 1 or 2. Responsive to questions posed at basic level. questions. We will be sending you also a list of very hard, medium to hard questions that we ask them to research. So that way, if you're really bored or you really want to spice up the hearings, you got a list of questions you can just push on them. So that way, you feel prepared as well. But these are medium to hard questions, so make sure that you're really gauging that within that level. Provides known citations for the case, also same list of cases that you've been hearing around. Illustrates a general command of the facts of the record, knows the record inside and out, and really understands the facts. They know exactly when, on the contract, where it's in the record, and reflects which email and the timeline of it as it relates to the facts, and then incorporates it into the law significantly. Very good, and this is where we're going to pick our quarterfinals, our semifinals, and our finals. It basically illustrates an extremely strong command of relevant facts and laws of the case. Very, very minor presentational flaws, and how to utilize the citations. Not just, they may also bring citations that are new, outside of what's been played on the record player, and used in a manner that's really new and advanced, and really has those 5 main arguments clearly stated. So that's a gauge of where this is. Before I move on, any questions?
You'll send us a copy of that?
Yes, along with a list of questions. Is this helpful?
Yes.
Okay, because I know before we just leave you at your will, and the subjective evaluations are great, but I think this is helpful to give people good feedback. And that's the last comment that I like to make is feedback. Yes?
You have a panel of 3 plus here?
It's 3. So you'll have 3, and each of the general rounds are 2 hours. No, we did them to 1:45, an hour and 45. And we'll have moderators that are going to be outside each room collecting your scoring sheets and keeping them confidential and making sure that you're on time. And we'll be WhatsApping everyone, making sure that they get there on time. It's extremely important that you show up early to your, prior to your time. And it's an hour and 45 minutes. In that hour and 45 minutes, you should be able to finish all arguments, but you have to have done at least one essential thing. This is a pre-moot. They cannot advance if they don't know how to develop. And the only way they can develop is feedback. Clear feedback. It's your choice as to determine whether you want to have everyone exit the room or you want to just have it there. Usually it's better to ask everyone to leave the room and then you score, give the scores to your moderators, then ask the team to come back, give them some feedback.
Yeah, in fact, not just better, it's necessary because we need to get the score sheets as early as possible.
Yeah.
So for that, so the first order of business after you've heard the argument is ask them to leave the room for a moment. The 3 arbitrators put down their scores, give them to the assistant in the room so that they can, and then give the feedback.
And all the moderators in the room are former Miss Moody's and arbitrators themselves, so they can stand in. And in your panel of 3, I think you have a presiding arbitrator and 2 other arbitrators, and one of you should usually take notes as far as the time, or have someone make sure to manage the time. And then I think you have about, they'll give you the order of the arguments. Is there anything else, Professor Brand, that I'm missing?
Basically, I'd make one point which
Yes.
Jimmy particularly asked me to make, and that
Yes.
is that it's going back to the point you already made about the fact that we've got 17 teams and therefore need to box and cox making sure that we've got 3 arbitrators for every session. And particularly at the beginning of the day, if people are late, please try to avoid being late, but also if you can, come down even if you're not on the first session but on the second session and catch up on emails or make a few telephone calls out in the quadrangle or find a quiet room to work in, then that would be really much appreciated, because if we need to call people in at short notice, we know that we've got a few extra people there.
And we'll set up the lunch area where we're going now to be available to you that day, and there's free Wi-Fi, it's quite comfortable, and there's a cafe there, and I think that'd be wonderful. It's a good networking opportunity as well for everyone to hang out, so very much appreciate that point. And I think that's as much as I have on housekeeping. I kept it short. Thank you for giving me only 10 minutes. But I'll take it. With that, we'll go back to questions. Before then, any other further procedural housekeeping matters? So you'll let me know for the dinners if it's a no, and you'll let me know if it's a no for the award ceremony, correct? And then we'll distribute arbitrator schedule shortly. Thank you.
Thank you, Mace. I think we'll get started here. We have not a lot of time, and we're going to stop at 2:25 and then shift to the symposium at 2:30. I do want to begin by making sure everybody knows Dr. Duncan Paz, who's with us, who is the Deputy Director of the International Chamber of Commerce MENA region office. And so this is the ICCYA sponsored program. Dr. Lamia, thank you for being with us for that. Do you want to say anything about?
Just a few words.
Okay.
Yeah. Words quickly. Hello everyone, I'm very happy to be here today. Just to introduce to you the new MENA practice that was established in Abu Dhabi last year, March last year. And actually the establishment of this office comes as a recognition of the increasing relevance of international arbitration in the MENA region. It is also in line with the strategy of the International Court to expand its geographic footprint internationally after Hong Kong, Sao Paulo, New York, today Abu Dhabi. The office has been operational since last year, and we are receiving local and regional requests. So basically, we do not yet have a case management team. This is going to happen in the near future, I hope. But I would like to share with you that the MENA region has generated the highest growth in terms of requests, arbitration requests type internationally with the ICC. So it is a region that is important to us, and we hope by establishing this office, the ICC International Court hopes to be closer to its users in real time and in local language, because we do receive requests for arbitration in Arabic. The ICC has initiated recently, since last year, a series of reforms, the 2017 reforms. And if we look at those reforms, we see that they do revolve around three values with respect to arbitral proceedings. Enhancing efficiency, transparency, and diversity. And by diversity, we mean in terms of gender diversity and generational diversity. And I do believe, our presence here cannot be a better testament to this commitment, being in the Royal University of Bahrain for Women and supporting the Pre-Moot competition. So I'm very happy to be here today, and I thank all the organizers. I'm going to be quick. CNDP, obviously, in the presence of the General Counsel, Mr. Boussil, Professor Brand, representing the site, CINE, the Royal University for this wonderful venue, the BCDR, and all the organizers who are helping to make this event a successful one. Good luck for everyone.
Okay, so we looked at some of the aspects of the jurisdictional question this morning. We looked at the path through the substantive law questions this morning, and we thought we might turn back to the second issue, which is the evidentiary question, and get people's thoughts on that and see where you think questions ought to go on that. Now, in terms of evidence, the starting point on that, we have one party asking for the tribunal to receive and use certain evidence. We have the other party asking for the tribunal to reject the submission of that evidence and not to consider it. So the legal framework here, of course, the parties chose the Hong Kong rules, and the Hong Kong rules have, in Article 22, language that says, of course, each party shall have the burden of proving the facts relied on to support its claim. Within 22.2, the arbitral tribunal shall determine the admissibility, relevance, materiality, and weight of the evidence, including whether to apply strict rules of evidence. That's it in the Hong Kong rules. Does that lead us to a clear outcome or a clear decision on the admissibility of the allegedly tainted evidence that comes from a prior arbitration involving the respondent? No, I see it's shaking the head. No, it doesn't. Does it give us anything we can go on? It does what it normally does, and arbitrators, I assume, like this. It gives the arbitrators a great deal of discretion, right? So how do you make an argument to the arbitrators when to exercise that discretion in your favor or where do you go with that? Now the parties chose the Hong Kong rules. They also have another choice of law. They have a choice of substantive law that's very clear, right? There's another choice of law clause that we find in just about every arbitration agreement, right? We have a choice of the seat, which is not a choice of a place for anything other than it is a choice of the lex arbitri. It is a choice of law clause. And what the seat brings with it in this case, the UNCITRAL model law, and the UNCITRAL model law has rules on conduct of your proceedings, equal treatment of the parties. Does that get us anywhere? Article 19, determination of rules of procedure. May, subject to the provisions of the law, conduct the arbitration in such manner as the tribunal considers appropriate. And then it says the power conferred upon the tribunal includes the power to determine the admissibility, relevance, materiality, and weight of any evidence. Okay? The question for arbitrators, when you arbitrate, do you like rules like this that give you a great deal of discretion, or do you like rules that give you a great deal of guidance? I see a nod of the head on discretion is a good thing.
Yeah, of course. If you're an experienced arbitrator, natural justice, if you have that option, sure.
Okay, in this case, you have that option. You have the question before you. Is the evidence in or out?
It's in, but what you do with it, it's relevant and it's in. And what you do with that beyond that, of course, it's up to the panel. But I'd say it's admissible. But, you know, is it going to be dispositive? I think that's another question.
And will you take, in determining how much weight you give it, will you take into consideration the manner in which it was acquired? Or does that matter at all?
It matters.
It matters. Yes. Why?
Because if there's fraud or...
If it was illegally obtained, does that make a difference?
Yes.
I don't think it matters because the fraud or confidentiality is a separate issues. They can sue separately for them. But I disagree that it has relevance, and I would not admit it because I think the prejudicial effect outweighs the probative value of that evidence itself.
You would not admit it simply because you determined it has no relevance.
Yeah, I mean, if to determine if there is relevance without any more guidance, to determine relevance, I normally use the prejudicial effect versus probative value. And I think this evidence, this prejudicial effect, will way outweigh the probative value.
Okay, we have one party in this case arguing against adaptation, saying the tribunal should not have, does not have the authority to adapt the contract. But we have evidence here that that same party in a prior arbitration had said an arbitration tribunal does have authority and can adapt a contract.
But what's the first characteristic of arbitration? That's confidentiality.
Can everybody hear? Should I be taking the microphone around, or you can hear? Okay.
So confidentiality. This is why we don't go to court.
Confidentiality.
Big cases, yes.
Confidentiality is one of the main reasons parties choose arbitration, right?
Yes.
And, okay, so, and which party is going to argue that position?
Which is the respondent.
The respondent.
Yes.
Okay, anybody want to state the claimant's position here?
Yes.
Okay.
Well, let's take another example. If a crime is recorded on the video, let's say on the camera, and it violates privacy rights, does this evidence become inadmissible just because it violates privacy, although it records a crime?
And assuming that it does, we decide it is relevant.
Yes.
Will questions of confidentiality or violation of privacy, those kinds of matters, should they lead to a decision not to admit evidence, even if that evidence may be relevant?
I don't think in this case, the situation, the issue of confidentiality is an issue for defendants, because they weren't part of the arbitration, they were not part of the breaching of confidentiality itself. They obtained the information from a third party who they paid as an investigator to dig up some sort of information. So in that sense,
yes, okay, there is a confidentiality obligation. There was in that prior arbitration, right?
yes,
There's a confidentiality obligation, and the question is, where does that come from? It exists in the Hong Kong rules. But which confidentiality obligation are we talking about? The one in the prior arbitration, or the one in which confidentiality obligation is being violated if we admit it?
The previous one. Yeah.
The previous one.
Yes.
But
they're not part of this, yeah.
That's for the arbitrators in the previous arbitration, isn't it?
Yeah,
That's not for me on this tribunal. I'm not violating confidentiality.
You might say there are principles of judicial comity, there should be principles of arbitral comity, and why should one arbitral panel be privy or condone the breach of confidence from another panel? And is this in the public domain, or is it not in the public domain? Is it if it's only in the public domain because someone pays $1,000 in crisp notes, is that in the public domain, or is someone facilitating the breach in the context of this arbitration?
The argument against that is that I don't have jurisdiction to enforce another arbitration confidentiality agreement.
But there may be comity considerations.
And even so, wait a minute, are you suggesting that I, as an arbitrator in this proceeding, cannot keep a matter confidential? This matter is already known by both of the parties. They're asking for it to be known by the tribunal. Is that really a question of confidentiality? I can keep it confidential. I'm not going to tell it to anybody else. Isn't that what confidentiality means in arbitration? Is that it stays between the parties and the panel.
That's a very myopic view of confidentiality, if I'm going to play devil's advocate, because you have to go one stage or two stages further and look at the circumstances in which, on your argument, confidentiality can be preserved within this new arbitration. It's only there because of criminality.
So what? Does it matter?
I would say,
Somebody else's criminality, right?
I would say regardless from where the confidentiality
confidentiality comes from, whether the old arbitration or the new arbitration. As a general principle, since the onus of proof always lies on the plaintiff, whoever is claiming that this evidence has been obtained in an illegal manner, it's his
so not on the party requesting that the information and the evidence be admitted. So you're saying the burden's on the party suggesting the evidence should not be admitted.
No, if I managed to prove as a respondent that the evidence that was provided by the claimant was illegally obtained, and I managed to provide sufficient evidence on that, then the tribunal is obliged to dismiss that evidence.
Where is the rule that says evidence obtained illegally should not be admitted? Is it simply a matter of admissibility, relevance, materiality, or weight?
On this matter, we can, as arbitrator, refer to the guideline of IBA, dating of evidence. This is very crucial because we cannot find on the Article 9 admissibility and assessment of evidence any things that mention about illicit means or illicit evidence. But we see that the arbitral tribunal at the Article 9 shall determine the admissibility, relevance, materiality, and weight of evidence. And on matter of confidentiality, there is any need to protect the confidentiality of a document created or statement or oral communication made in connection with and for the purpose of providing or obtaining legal advice. Any need to protect the confidentiality, they can take some arrangements to keep those documents confidential, but there's nothing to keep this document without using it. We have to use it, but to protect it by confidentiality. The arbitral tribunal can take several steps on this matter.
This was Article
9, 3. It mentions the confidentiality. The arbitral tribunal may, when appropriate, make.
And then we have a comment up here. Go ahead.
I'll come back on that, Elias, because if you look at Article 9.3 of the IBA rules on taking evidence, it simply talks about what the arbitral tribunal may take into account. It's permissive. And then if you go down to Article 9.4, the arbitral tribunal may, so it's permissive. Where appropriate, so it's doubly permissive, sort of, well, we think the answer's that. May, where appropriate, make necessary arrangements to permit evidence to be presented or considered subject to suitable confidentiality protection. Does that help an arbitrator?
Let's get another.
Just give it to them.
Okay.
Under his discretion.
Good. Let's get another comment. Okay.
First, I would like to draw the line between the way you collect your evidence and if it's legal or not legal. Okay? There's a different story from how is the arbitral tribunal going to deal with the evidence. So, in my view, the arbitral tribunal has to rely on the evidence or not. Okay, it will rely on the evidence or not regarding its credibility and admissibility, regardless to the way. How did you collect your evidence? Is it a legitimate way or it's an illegal evidence? And this will be subject totally to the penal code. Okay, and if there is any illegality in the evidence, and there is a particular definition in the penal code. Okay, so this you go to the criminal court at the end of the day, and this is totally different story from how is the arbitral tribunal going to deal with the evidence. Okay. Shall I rely on the evidence as an arbitrator or not? It's a different story. Okay? This is on one hand. On the other hand, regarding the confidentiality duty, okay, and confidentiality is a mandatory rule imposed in some legislation, such as the Saudi Arbitration Law 2012, Egyptian Arbitration Law 1994, Article 44, as far as I remember. Omani Arbitration Law 1997. It's very similar to the Egyptian law, as if they are both copied and pasted. Okay, so confidentiality is a duty imposed pursuant to arbitration legislation in many countries. Yeah. Okay, as a matter of fact, there is no penalty connected to this duty, but it is a mandatory rule. And the confidentiality extends in those legislation to the arbitral award. Can I disclose the arbitral award or publish this arbitral award without a consent, written consent, prior written consent of the disputing parties or not? This is the point, okay? And secondly, if there a penalty connected to this duty,
if nobody who had the obligation, if nobody who had the obligation of but I want to follow up on that question, because if nobody who had the obligation of confidentiality disclosed, or we don't know it.
In private-public arbitration, it's totally different. I was in Max Planck Institute in Heidelberg with Professor Stefan Schell some time ago, and we have discussed that the private-public arbitration is a totally different story, because it's relating directly to public interests and public fund and the right of the public to know the arbitral process. Sure. It's a different story. But as a matter of fact, in Arab legislation, Egyptian legislation 1994, Omani 1997, Saudi 2012, I believe also in Bahraini Arbitration Act 2015, there is a duty of confidentiality not to publish or disclose the arbitral award in both private arbitration and private-public arbitration, in both types of arbitration, whether the state is a party to the arbitration process or not. So it's a very critical issue, confidentiality, and it differs from jurisdiction to another in the light of the arbitration.
Okay, but in this jurisdiction, which brings us to the question, are the IBA rules the law in any jurisdiction?
It's a
guideline.
International,
right? It's a private.
But as far as the parties and the arbitral tribunal is obliged to apply the IBA rules.
Obliged? Required?
If it is stipulated by the disputing parties.
Do the rules of private international law ever lead you to a rule of law that requires you to apply the IBA?
No. But as far as it is a contractual requirement by the disputing parties.
If I'm an arbitrator, I have complete discretion to refer to them, and they're useful, right? Let me ask this: Are they the only source of soft law rules out there to deal with this type of issue? No. What else is there? Well, what? Well, no, the Hong Kong arbitration rules, we've already looked at it. They have the same language as we had in the UNCITRAL model law, complete discretion to the tribunal. There's nothing more than that. Is anybody familiar with the Prague rules? There's a new set of rules for taking of evidence in international arbitration that was developed in the last year. Quite often the Pre-Moot problem raises issues that flag new developments in the law. The Prague rules are specifically designed and are explicitly stated to be for inquisitorial arbitration, not for because they find that the IBA rules are too common law oriented, and they want a set of rules that's more civil law oriented.
Common law is prevailing in terms of international arbitration.
What's that?
Common law is prevailing in terms of international arbitration. This is practice.
I like that. That's the rule today. That's the rules.
I was going to say there's also a policy aspect, right? That's always your go-to argument in court, right? Even though we have confidentiality in arbitration, there's always a policy. Are you saying to your parties, I don't really care how you go out and get the evidence, like go for it, go spy, go cheat, go steal, I'm going to consider it. So in that case, admissibility.
Well, how do you deal with the response that says that should be dealt with separately? They can be they can be prosecuted for a crime, or you can sue them for damages.
Actually, I was going to say the same thing, but I will take it one step further. if it's in a jurisdiction where it's actually a policy, like let's say it's such a privileged information of like doctor information or whole product, that can be a public policy challenge to the award they're on if the tribunal doesn't take it.
Okay, let's go back. Let me just go back to Pre-Moot. It was suggested this morning that there's a good faith obligation of the parties in carrying out the contract. Is there a good faith obligation then in once they get to dispute resolution and how they go about that? Does that good faith obligation carry over?
We have to look to the Arbitration Act of Danubia, because it is the governing law of the place of arbitration. If we find that there is some laws or provisions regarding the illicit evidence or how to assess the evidence, it will be a law to be implemented, not to regardless of the discretion of the arbitrators. So means if this
here it is.
Yeah.
That's all we have. The power conferred upon the arbitral tribunal includes the power to determine the admissibility, relevance, materiality, and weight of any evidence.
So we have to go. Okay, in Swiss, there is a provision in Switzerland, Swiss Arbitration Act, which means illegally obtained evidence shall be considered only if is an overriding interest in finding the truth.
Okay, and that why shouldn't that have the same authority in this arbitration as the IDA rules? Because
have to find the balance.
Neither one is more binding on this tribunal than the other, but we can look to them as persuasive authority, right? That's the only way we can really use it.
I have a provision. I will go back to Hong Kong rules.
Yeah.
We have 13.5.
3.5?
13.
13.5. Yeah.
Yes.
Fair and efficient conduct of the arbitration. Does that weigh on this question?
Sure.
Is it unfair to admit illegally obtained evidence? Now, how many think that this evidence will, some think it's not even relevant, is anybody who thinks it will clearly help decide the case?
Can't we follow through by asking how you regard 13.5 as being relevant, so we know what to argue against?
Well, in a sense, that the question would be fair, except for admit evidence was illegally taken. And is it fair that the claimant has an evidence and does not have the right to submit it? So
We're in the realm of competing fairnesses. Fairness to present the case, and a fairness not to have your confidentiality breached.
Right.
Whose fairness wins?
Well, it's an argument.
You're nominating yourself as counsel rather than as officer.
I was just going to say that my primary concern with the enforceability of the award, should I accept this evidence? Because depending on how this evidence was obtained, and depending on what sort of civil liability named to separately to the other contract, or whether it was a criminal liability.
So what is it, what rule would prevent the enforceability of the award?
What's either in public policy, because if it's criminal liability, then that's a whole
Now, this is interesting because that rule in arbitration law is the basic source in Article 5 of the New York Convention, right? But Article 5 of the New York Convention goes only to enforceability of the award, and right now we're really dealing with how does the tribunal deal with the agreement? Okay, but this is an argument that the students should be able to do, to wrap Article 5 into not just Article 3 enforcement of the award, but Article 2 enforcement of the agreement by saying you, the arbitrators, and you can find it in some of the rules, have an obligation to render an enforceable award. Okay? But you've got to then show if you admit the evidence or if you deny admission of the evidence. And if it would be unfair to admit the evidence, and that violates public policy. What if it's unfair to deny admission of the evidence? Would that be a violation? Where does that leave you?
I think there's always those problems. It's balancing between two heavyweights. On the one hand, we have confidentiality, which by all means is highly important. On the other side, we have Article 5 of the Convention, 13.5, also encapsulating due process. That's the other end of the spectrum. So the arbitrators have to really evaluate is confidentiality really that important to knock out due process in certain circumstances. And let's not forget that even 45.3 under the Hong Kong arbitration rules, it's confidentiality is not an absolute right. Actually, 45 has exceptions itself as well. So it softens it up a little bit.
Let me ask an additional question here. Suppose that the award, the copy of the award, was illegally obtained by the party, but it's also now available through other sources because it's been published by someone.
And I would go.
It's because this party obtained it illegally, even if it's available without any illegality, does that change the analysis?
Yes. As far as I remember, it's Article 5.2b, your convention, Article 5.2b regarding the enforceability of the arbitral award. So if I'm making a interpretation to Article 5.2b, I will not go far beyond the Article 5.2b terms and phases, which stipulates that the enforceability are subject to public policy considerations, the enforceability of the arbitral award. But what's far beyond? Okay, so what's before the arbitral award?
5.2b is typically construed narrowly, right?
Okay, it's a matter of how to prove beyond in front of the national judge that this arbitral award was obtained and was relying upon false evidence. I mean, in terms of practice, very difficult to prove it. Yeah. So, how can you go far beyond?
I think 5.2b is irrelevant because of the procedure order number 2, 46.
Procedural order number 2. What page is that? It's paragraph 46.
61.
61.
Are there any specific rules on evidence of particular in the 3 countries? And the answer
Which paragraph?
46.
46. Page 61. Okay. Are there any specific rules on evidence, in particular, how to deal with evidence obtained by breach of contract? So are there any rules in the courts in these countries on this? No, but there's no rule one way or the other.
But is it a public policy here if there's no?
Now, we've talked about national law. What?
I'm just going to say that on the public policy point, I was having a look at the Prague rules, and that ducks the issue. Similarly, consistent with civil law approach, it gives a greater inquisitorial role so far as the arbitral tribunal is concerned. But in my reading of Rule 7.2 is that it specifically does the law. But then you come on in the Prague rules to something which we haven't touched on, but which could again be relevant. And that is if the tribunal required production and then production were not forthcoming, would the tribunal be entitled to draw adverse inferences and then get round the problem A, of disclosure and B, of public policy, because it shifts the focus to something which is purely factual? We ordered disclosure, this hasn't been produced, we're going to draw adverse inferences.
I was also going to say that for the integrity of the system, I mean, that really, the way you did that, that's brilliant to man's production. I think that's a really excellent way to do it. But also for the integrity of the system, arbitrators should exercise restraint, right? Instead of sort of, well, I'm just going to worry about this case and everyone else. Because there is confidentiality.
But how do you exercise restraint? By leaving the evidence out or by taking it in?
No, I think it's illegal, and you're going to look at a policy aspect that it should not be entered. I think Michael's actually answer is brilliant, requiring that party to submit it. That's the perfect way around it. But I think as far as the integrity of the system goes universally, you don't want everyone to say, well, in arbitration, it doesn't matter. You can go and steal, lie, cheat, and get your evidence. They'll take it. right? Versus in the court, and the judge is probably not.
I would have concerns about, if I was on the panel, going beyond the mandate in ordering such disclosure. First of all, it's another case, it's another arbitration, not the arbitration at hand. And secondly, mindful of the confidentiality obligations. So I would never order that disclosure to begin with. And if I were the counsel, and I would object to that request.
I would totally agree that if we were litigating this, then definitely. But here the question is, should claimant be entitled to submit evidence as opposed to actually can the tribunal order or should they order? Is this relevant or material to the outcome? So I'm wondering, and honestly we consider doing this argument, but are we supposed to actually make this argument? Because that would be too easy. I mean, we can ask the tribunal, we know they have this document, please ask them to submit it, and they're actually bound by Article 45 and 3B to submit it. But that's not the question asked. So I'm not sure we can.
I think we have to extrapolate a little bit on it, because what difference would it make if I'm the party, I have submitted it, but then is that, when we say that's the only question we addressed, then it kind of doesn't go anywhere. Parties can always submit evidence as whether or not the tribunal will receive it and use it, right?
I mean, of course, yeah, I'd be more than happy to do the argument, honestly. Like, it's very consistent, super consistent. But then again, I think the drafters of the Moot want us to have to go into this debate between weighing in the benefits of the different heavyweight problems that we're at stake that we're discussing now, as opposed to providing one easy solution. Because then it would be simple. We would have to determine that this is indeed relevant and material to the outcome, and then tribunals should be entitled to ask the party to produce it.
I guess it depends on what's meant by the word submit. So submit just means offer. Any party can offer evidence. I'm not sure we can determine that they can't offer evidence, is whether or not they do anything with it. Isn't that the real question?
I mean, honestly, I'm not sure. I'd be more than happy to do this argument. I'm not sure how arbitrators are. I'm not sure to what extent they're aware of the formulation of the problem. That's one thing.
Yeah.
The second thing that is telling about the drafting of the proposition of the question is that they continue by saying on the basis of the assumption that this evidence had been obtained either through a breach, etc. So they want to emphasize that the behavior of one party and that party's intent to submit the same document, as opposed to the power of the tribunal itself. So again, if you consider that we're supposed to argue beyond the party's entitlement to submit per se, then okay.
One comment, then we'll let Professor Meske say something.
Just short. So
go ahead.
The legality is a presumption, as you said, so you have to argue under the presumption that it was obtained illegally. And for document production, you have to prove the same requirements as for submitting evidence under 22(3), because it said you have, again, to prove relevant material. Exactly. And then you have, again, confidentiality, legality. So it doesn't make any difference except for that the claimant would not have to obtain it illegally from this ominous company. So that would only be the change. The claimant would not be involved in it. It would be the arbitral tribunal. But I think that you need to argue submission.
But wouldn't we be circumventing
I believe so.
the problem of illegality if we go through that road? I mean, then again, there would be no illegality. We would be circumventing that in a certain way. Honestly, I don't know. I'm confused.
Okay, we're getting close on time. How many admit the evidence? How many admit?
No, not even.
What?
No, not even.
What? How many?
I would say it is relevant, but it is not material to the outcome.
Okay, 3 questions. You can admit it, you can exclude it, you can admit it but not use it, and determine it's irrelevant.
You cannot admit it if it's not material to the outcome, because these are cumulative conditions under 22(3). And that has to be relevant and material to the outcome.
Okay, so then you would so you would deny admissibility. So how many would admit? How many would exclude? Okay, that B shows, and how many aren't sure yet? But the show of hands shows me that the problem, as drafted, is pretty balanced, which is nice.
You can ask 3 questions, but you will never have one answer. You can't have one answer, because there is no one right answer, and the others are wrong. I mean, in my view, it's not like that.
Because the tribunal has discretion.
Yes.
The rules protect the arbitrators.
Each arbitral tribunal has its own approach in the light of the factual background of the particular case. Okay?
Yeah.
There is no one right answer, in my view, and the other answers are wrong. It's a case-by-case scenario, okay? Depends on the approach of each arbitral tribunal.
But let me suggest something more, and then we need to wrap up. But this is an interesting question because the respondent is objecting to the admission of the evidence. Right? Now, what's the value to the respondent to objecting to the admission of the evidence? One is it may, if successful, keep the evidence out. Right? That's the obvious value. It seems to me there's a secondary value here to the respondent making the argument. It's basically saying, look at the bad faith not only of the claimant but of claimant's counsel here in this process, and just raising the objection allows you to imply all of that and hope that it might have some effect on other aspects of the decision as well. I won't ask whether you as arbitrators would allow that to happen, but worth thinking about.
What about your answer? I'm interested in your answer.
What's that?
What about you?
What about me? I would withhold judgment until I ruled on jurisdiction.
I would say any allegations and assumptions that the respondent would come up with, they're still, as of this stage, assumptions and allegations. Until he proves that these evidence should be set aside.
Okay.
That's
we're on the response.
Fair response.
Okay. All right. Thank you all. Not just for being arbitrators, but for engaging in this discussion. This is one of my favorite, it's become one of my favorite parts of this whole process because it's so much fun to have this kind of discussion. I'm going to hand out